Hello, today on Spilling Secrets, we are talking about intellectual property assessments and trade secret assessments. What are the key differences between the two and why are both necessary? Welcome, everyone. I'm Greg Krabacher, a partner in Epstein Becker Green's Intellectual Property Practice Group. I'm located in EBG's Columbus, Ohio office. Spilling Secrets is a podcast series about the future of non-competes and trade secret law. On each episode, we feature an all-star panel of attorneys talking about real-life problems, developments, and strategies when dealing with trade secrets, non-competes, and other types of intellectual property. With me today is Dan Levy. Dan is a Newark, New Jersey-based attorney in Epstein Becker Green's Trade Secrets and Employee Mobility Practice Group. Dan, welcome to Spilling Secrets.
Thank you, Greg. Happy to be here and also excited to be joining the Spilling Secrets team as a regular panelist and host.
We're also joined today by my partner in the IP group, Hemant Gupta, who focuses on intellectual property and technology. Hemant's located in Tennessee. Welcome to the podcast, Hemant.
Thank you, Greg. It's a pleasure to be part of today's exciting topic.
Today's discussion focuses on intellectual property assessments and trade secret assessments. When it comes to trade secret assessments, there's been an ongoing attack on the use of non-competes both at the federal and state level. So it's becoming increasingly critical for employers to take action to protect their confidential information. But companies should also take stock of their other IP assets so that they can build comprehensive plans for protecting and enforcing all of their creative and innovative endeavors. By the way, if you like what you hear on today's show, please subscribe. You can subscribe on our website at ebglaw.com/subscribe. Historically, employers have largely relied on non-compete agreements to protect their confidential information from being shared with competitors. But there's been a lot of activity recently at both the federal and the state level. Dan, can you elaborate on the ongoing attack on the use of non-competes?
So if you're a regular listener to this podcast, you know that the FTC passed a rule that would have banned almost all employer non-competes. As we had predicted, the FTC rule was enjoined and has likely gone away. But that's not the end of the story. There has also been an effort by many states to restrict or prohibit the use of non-competes. For example, Minnesota recently passed legislation banning almost all non-competes. Several states allow non-competes, but with limitations enacted through legislation that requires employers to comply with various procedural requirements, such as a minimum salary or providing notice of the non-compete to the employee or prospective employee. Other states, including New York, Maine, and Rhode Island, just to name a few, introduced legislation seeking to ban non-competes, but they were vetoed. We anticipate that now that the FTC rule is likely dead, more states will seek to pass legislation to ban or limit the use of non-competes. And it is for this reason that it is critical for companies to conduct what have traditionally been known as trade secret audits, but I don't particularly like that nasty audit word, so I like to call them trade secret assessments or even better, trade secret tune-ups.
Let's step back for a minute. Dan, can you explain more about what a trade secret assessment is and why it's so important?
Absolutely. So it's a holistic approach aimed at identifying the company's most valuable assets, followed by assessing and improving upon the methods used to protect those assets. The ultimate goal is to ensure that the company's crown jewels are best protected. In the event of a misappropriation of that valuable information, the company is well positioned to detect that misappropriation and swiftly respond to it through legal action. The assessment involves a four-step approach. The first is to evaluate the company's trade secrets and other confidential information, as well as the documentation aimed at protecting those valuable assets. This includes 1, cataloging the company's trade secrets, 2, reviewing and bolstering confidentiality agreements with employees and non-disclosure agreements with vendors, and 3, updating policies and procedures aimed at protecting the information. Then, the second step is to discuss with key stakeholders the most effective way to implement the policies and procedures. This typically includes discussions with human resources, information technology, and/or information security, legal, and the appropriate business leaders. The third step is then to examine the company's detection and response, including the use of implementation of a data loss prevention platform. This step includes evaluating the company's security measures, training, and exit interviews, as well as other processes that would be best enable the company to swiftly respond if it detects a theft of confidential information. The final step is to discuss with the company methods to improve any of the company's blind spots. The goal is to improve prevention and detection so the company is well positioned to swiftly respond to a trade secret incident.
Thanks, Dan. Let's shift gears for a minute. Hemant, can you tell us what an IP assessment is and how that may differ from a trade secret assessment? Do they complement each other and safeguard a company's assets?
Sure. An IP audit is a comprehensive review of a company's entire intellectual property portfolio, including patents, trademarks, copyrights, and trade secret. It aims to identify, catalog, and assess the value and protection status of all IP assets. During the IP audit or assessment, we identify the assets and ensure that the company has all the proper assignments and protections in place. A trade secret assessment, on the other hand, focuses specifically on identifying and protecting confidential business information that gives the company a competitive advantage. While more narrow in scope, it delves deeper into the management and security measures for trade secrets. These processes complement each other in safeguarding a company's assets. The IP audit provides a broad overview of all intellectual property, while the trade secret assessment offers a targeted approach to protecting sensitive information. Together, they ensure a company has a complete understanding of all of its intellectual property assets and can implement appropriate protection strategies across all types of IP.
Gotcha. So if we drill down on just the IP assessment side of that, can you tell me more about why that side is so critical today?
Well, if a company doesn't have a full appreciation of all of its IP assets, they miss out on opportunities to build stronger brands, to protect their competitive edge, or even to earn licensing revenue. They may even lose out on potential investment or acquisition opportunities because the interested party may feel that the company isn't doing the basics to protect investments in their R&D or brands. From a patent standpoint, with rapid technological advancements, companies need to regularly assess their patent portfolios to ensure that they're protecting innovations effectively and not infringing on others' patents. This is especially critical in fields like medical devices, software development, and manufacturing. Additionally, as digital platforms proliferate, protecting and managing a company's brand across various channels becomes more challenging. An audit helps identify gaps in trademark protection, ensures consistent brand usage, and uncovers potential revenue-generating opportunities. Finally, the increasing reliance on software in virtually all industries, coupled with the rise of open source components, makes it critical to audit software copyrights. This helps companies navigate licensing complexities, ensure compliance, and protect their proprietary code in an interconnected development ecosystem.
Dan, can you help us with a few concrete examples and help us understand why it's so crucial from the trade secret assessment side to begin this process now?
Yes, and to that end, there's a recent study showing that 75% of employees have admitted to stealing from their employers at least one time. Leaving aside the status of non-compete law, employees are stealing information, and employers, for the most part, do not know it is happening. The most important reason for conducting a trade secret assessment is to protect not only the company's most important crown jewels, but all of its intellectual property. And that goes to what Hemant was just saying. But I can give you a couple of examples from my experience in my practice. First, I had a client referred to me that had an employee resign from its New Jersey office who made a demand to be paid a bonus that she claimed she was owed. In working to respond to the former employee's demand, the company discovered that the employee had emailed confidential information to her personal email account. The client, unfortunately, had no measures in place at the time to detect this information and discovered the conduct only because it was looking into the former employee's claim for a bonus payment. While this should have been a slam dunk trade secret case, the client had no measures in place. It did not have confidentiality agreements, no policies aimed at protecting confidential information, no training to protect confidential information, no exit interviews, and it didn't have anything in place to detect the theft or misappropriation of confidential information. While it had a breach of duty of loyalty case under New Jersey common law, the client was unable to pursue a trade secret misappropriation claim because it simply did not and could not establish an important aspect of such a claim, namely that the employer must have reasonable measures in place to protect its trade secrets and confidential information. So the company learned a valuable lesson that day and subsequently has conducted trade secret assessments and updates on a yearly basis. And then on the other side of the coin, we represent a client that undertook regular trade secret assessments. And when one of its R&D engineers resigned and stated he was going to be leaving the country, the client immediately checked his downloading conduct and discovered that he had downloaded all of the IP for a new medical device that had not yet hit the market. That provided enough evidence for us to go to court on an ex parte basis to get a TRO that allowed us to contact the federal authorities and place him on the no-fly list. The client also reported the theft to the FBI, and it resulted in the execution of a search warrant, subsequent arrest, and guilty plea to trade secret misappropriation under the Economic Espionage Act.
Let's get into the nuts and bolts of what a trade secret assessment actually includes. How can a business protect their trade secrets if they pursue an assessment strategy?
Yeah, absolutely. And you mentioned it, Greg. Prevention is the key. Confidentiality agreements are necessary, but that is not enough. Periodic training that reminds employees of their confidentiality obligations is quite important. I recently completed a 45-minute virtual training for a client that was recorded. So any employees who were unable to attend the live training were required to listen to the recorded version. Each employee signed an acknowledgement that they attended the session. Preventing employees from downloading to removable devices or through apps is also important, as well as trying to prevent or at least detect email conduct of transferring files to personal email accounts. Detection is also key. So employing a data loss prevention or DLP program is also critical to detecting whether employees are engaging in questionable downloading or transferring conduct. But with the DLP, you also need to remember that you need someone to monitor that conduct. Just having the program is not enough. Finally, exit interviews are important to have HR remind employees of their obligations upon departure from the company. Heyman, what are some ways businesses can best protect their IP portfolios through an IP assessment?
Only after a company takes stock of their IP assets can they effectively build an IP protection strategy. From a trademark perspective, once they catalog all of the brands, logos, and taglines they're using, they can develop a plan to file trademark applications on the most important marks and create branding guidelines to ensure consistent usage that builds strength in the brands. For technology, it's important to identify what new technologies may be patented or protected by copyrights, as well as who contributed to the creation so that the proper assignments can be obtained as early as possible. I once worked on a deal for the sale of a software company that nearly cratered because the company being sold couldn't produce the copyright assignments from their developers who worked on a portion of the software. Without the proper assignments, the copyrights for that portion of code were still owned by the developer, who was located in a foreign country, and he couldn't be located. As a result, the value of the company plummeted because they couldn't show that they owned 100% of the software. The deal was only rescued by having programmers create new code from scratch. All of it could have been avoided if the company had performed an IP assessment as a routine part of their business operations.
I have a question for both of you. Can you share some common risks that companies face if they neglect conducting trade secret assessments and IP assessments?
Sure. As I just mentioned, a company may fail to ensure that they actually own the assets that they think they do, especially with respect to copyrights. They may fail to recognize valuable intellectual property. Under patent law, there are strict deadlines by which patent applications must be filed, and so it's possible that otherwise protectable assets could lose the ability to be protected by patents, both here and around the world, and the technology could become part of the public domain. Additionally, if copyrights or trademarks are not protected, a company may lose the ability to enforce those rights in federal court or prevent a competitor from using them. Of course, a company may also lose potential licensing revenue or opportunities from interested buyers if they don't have their IP protected.
Oh, that's interesting, Iman, that copyrights and trademarks may not be protected and a company may lose the ability to enforce those rights in federal court. But similar with trade secrets, if a company doesn't take reasonable measures to protect them, they might lose out on the possibility of enforcing or pursuing a trade secret misappropriation claim. In addition, on the trade secret side, that 75% of employee theft, I think, is a key number. If your confidential information leaves, you may not even know it. And if you do somehow discover that there's been a misappropriation of your information, having reasonable measures in place is a prerequisite of bringing a trade secret claim. Conducting a trade secret tune-up or assessment ensures that all of the elements a company needs are in place to protect its information. This includes notifying employees of their obligations, preventing a misappropriation in the first place, detection if misappropriation occurs, and finally, being able to quickly respond to a misappropriation to prevent dissemination of that information.
So, as we think about how to take this concept and put it into practice, Hemant, can you walk us through how to create a comprehensive IP assessment that ensures that a company's IP is fully protected?
The first thing is I think that companies should conduct regular assessments. I recommend doing an IP assessment at least on an annual basis to ensure that recently created technologies don't lose the ability to be protected. And then, as Dan mentioned, just as training is required for trade secrets, we also recommend regular training of employees who are in creative roles, such as marketing or product development, to ensure that they understand how to protect potentially protectable IP and that they know how to build strong brands that will have the most value over time. Our IP team regularly conducts these trainings, and our clients have found them to be extremely valuable.
Thanks so much, Hemant and Dan, for a great discussion on IP assessments and trade secret assessments.
Thank you. I always enjoyed talking about this exciting area of law.
Thank you. I think this was an informative discussion on IP and trade secret assessments.
And a special thank you to our listeners. If you'd like to subscribe to the show for free, please go to ebglaw.com/subscribe and click the box for Trade Secret and Non-Competes /Spilling Secrets podcast series. Thanks again for joining. Until our next episode, this is Greg Krabacher signing off on behalf of Spilling Secrets.
This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.